and I'll give you all a series of examples of what's happening nationally and locally, and I would suggest that it is time to get on the horse and start riding it in a better direction if we're going to get some control of the situation. Well, there's some perennial areas of concern, and this just keeps happening, keeps going on. There's always new regulatory initiatives, but beyond that, the existing regs that are on the books are constantly being reinterpreted to be more restrictive than what you were originally told they were going to do. Now that's a problem, because that doesn't even give you an opportunity to comment on what's going on. They just change it when you're not looking. Regulatory processes are becoming notoriously incomplete. And what I mean by that is they propose drafts, they never adopt them, and then they implement them as if they were the adopted rules. They're doing that in this state on TMDLs, on other water quality proposals, as if things were completed and you had your opportunity. And EPA is behind, actually, the state's doing that. Catering to environmental groups has always gone on to varying degrees. The question is whether or not they start to hear your voice as much as the other voices, because a squeaky wheel does apply here. The person that squeaks louder gets heard more. Failure to update obviously outdated science. This has been a problem for the last, I want to say, 15 years, ever since EPA pretty much shut down all of its national laboratories where they used to have the scientists that used to update the federal regulatory information. Since they're not there anymore, it's not being done unless you do it. And then last but not least, high cost impacts and failure to prioritize. One thing is for sure, they will keep rolling out initiatives one after another, like, planes taxiing at O'Hare, waiting to take off. And they don't really care whether or not you can afford to do all of them. That's not their priority. Or in other words, they're not going to stop until you drop. Now, here are some of the new regulatory initiatives, and I can tell you that collectively, this is probably 20 billion or more of initiatives just for this state. Nationwide, the number is just staggering. Your state put out a nutrient policy. And when we talk regulatory tsunami, it's interesting. Steve and I have been working with NESERB for a long time. And things were quiet, relatively quiet, for a number of years. And then I want to say somewhere around maybe November, October of last year, things just got kind of belched out, so to speak, of the PCA, where they started issuing a series of series of restrictive requirements all at one time. Nutrient policy just came out. What does a nutrient policy mean? Anybody that's discharging to anything that's a tributary to the Mississippi River runs down to the Gulf of Mexico. The Gulf of Mexico's got a dead zone. You've all heard of that. What Minnesota said is, we're stepping up. We're going to make all our treatment plants remove nitrogen. Well, I don't even know how much, and some of you don't have any of your nitrogen makes it to the Gulf of Mexico. But they just said, we'd like to see nitrogen removal for all. Now, where were you given an opportunity to comment on that? Answer, not. PCA stream standards for nutrients. This is basically going to be filtration and chemical addition for virtually everybody that discharges to a stream. They were also working on nitrate toxicity standards. No one in this country has a nitrate toxicity standard. Nitrate is generated when you remove ammonia at your wastewater plants, which most all of your wastewater plants pretty much remove ammonia. It's a good thing to do. But it converts it to nitrate. Now they're claiming that nitrate is toxic. And that means whether or not you go to a lake, a river, or wherever, you're probably going to have to get nitrogen removal for that reason. EPA put out new ammonia criteria. They're 50% lower. EPA changed the bacteria standards to impose daily maximum numbers. Now, all you need to know is there's runoff from your communities. Every community has some runoff. And everyone has dogs and cats, and there's critters and raccoons and squirrels and deer and all kinds of other things that are running around where your runoff is. If you go and measure the bacteria level in your runoff, I will guarantee you, you will blow these bacteria standards. Everyone in the country does. And they are now going to create a situation where that's going to be a violation of the Clean Water Act. That's not good. Why? Because they're changing the definition of waters in the U.S. to include roadside ditches, which we're going to assume are fishable and swimmable. Wonderful. Their proposed anti-degradation rules, I'm not even going to go there. So sediment TMDL, this is another one for everybody that's tributary to the Mississippi River. They did a draft sediment TMDL. There was a huge hoopla over whether or not it was reasonable or not. It was never finalized, and it came up with very stringent requirements for all of the municipalities that are tributary to the Mississippi River. Even though the vast majority of the sediment in the Mississippi is from natural erosion. Wonderful. And last but not least, EPA just, for example, launched a lawsuit against 89 communities in Pennsylvania. Why? Pennsylvania is tributary to Chesapeake Bay. Chesapeake Bay has nutrient requirements. The nutrient requirements weren't being implemented through the stormwater program. Oh my, now you've got to figure out how to get nutrients out of your stormwater. So these requirements are going to be massively expensive, and more are coming. Okay, so what else is going on? If you don't like the answer, ignore it. This is actually pretty bad. Mercury minimization plans, almost everybody's getting them. For years, communities have been showing that the mercury in your discharges is virtually nothing. They keep making you monitor it. They keep making you do plans as if you have to minimize it. They're spending your money, it's doing nothing. EPA Science Advisory Board told EPA to stop using simplified methods to complex nutrient issues. EPA's answer, the Science Advisory Board agreed with us. I don't know how a 46-page critique with issue after issue of what the agency is doing wrong turns into an agreement, but that's what they said, and then the state of Minnesota followed that advice. Bypass rule. They're saying the federal bypass rule makes you have to operate your sewer system in a flood. You're supposed to flood-proof your sewer system. I don't know how you do that. Iowa League of Cities decision. That was another one. We'll talk about that in a little more detail. I'll skip over. But basically, this is one of those Popeye moments where one of my clients, the Iowa League of Cities, said, that's all I can stand and I can't stand no more. We sued EPA over some rule reinterpretations that were going to cost billions of dollars in Iowa unnecessarily. We win the case and EPA decides it's going to ignore the judge's decision. Really? This is your government in action. Well, you get the idea. If they don't like the answer, they pretend the answer didn't happen. Again, that's not good. Why? Because when they do that, you're the one that pays more. Now, a good example of ignoring the science, which is a shame, because the reason MESR was established is because we were doing scientific approaches to try to make your money spent in a more effective and better way. And when PCA recently proposed and then adopted stream standards, we brought in a various number of expert opinions, and we were not opposed to them adopting stream nutrient standards. It was just a couple of the things they added in that were clearly inappropriate. Stephen Schapper is one of the leading experts in the country on how to properly regulate nutrients. He gives an expert opinion that one of the methods they're using has never been used, isn't accepted by the scientific community, and doesn't actually predict nutrient effects. They ignore it. Thomas Gallagher, who I've worked with for 40 years, Tom Gallagher has done more water quality projects than God. And I asked Tom about one of the situations that the state was trying to regulate. They were trying to regulate how much dissolved oxygen bounces up and down in the stream. Okay, so that's a question. Maybe you should regulate it, maybe you shouldn't, but we'll look at it. I asked Tom, the degree that they want to regulate that bounce, I said, is that something you commonly see in pristine waters in background areas that aren't affected by anything? He goes, John, the variation in background waters is higher than what they're regulating. Or in other words, they were regulating you down to a zero impact. They ignored those comments. So it's unfortunate. We're developing science and information, and clearly they are just thinking they can ignore us. That is not a good situation, because if you can't get them to look at the science, you really don't have anything else to protect yourself with, short of going to court. And speaking of which, this was the Iowa League of Cities case, where EPA reinterpreted 2 rules, nationwide impact, couple $100 billion. I mean, this was pretty bad. And these are the kind of quotes that were in the case. EPA's action was tyranny of small decisions. They tried to eviscerate appellate review. They tried to eviscerate state discretion. Was rulemaking masquerading as explication? You're not explaining the rule, you're modifying the rule. Their position was irreconcilable with the adopted rules. Their explanation of what they were doing was Orwellian newspeak. Now this is the 8th Circuit. These are about as level-headed and calm a group of circuit court judges as you can get. And they were basically blasted the agency, vacated their rule decision, and said, you know, you don't even have authority to do what you're doing. What did EPA turn around and do? They said, this is the 8th Circuit. They said this 8th Circuit decision that said we were grossly misinterpreting our regs and modifying them illegally only applies in the 8th Circuit. So in other words, if I'm in New Hampshire, they're still going to apply the interpretations that the 8th Circuit said were totally illegal. Suppose somebody else, another municipal group, sues in the 3rd Circuit and catches EPA doing something illegally. Now EPA's position is, well, if folks from Minnesota didn't join in that suit, we're not going to apply that decision and respect it in Minnesota. That's outrageous. That is not how the Clean Water Act was set up. It's supposed to be uniform laws across the state, not I can just by whim apply different interpretations of the same exact rule to different people. So now they will force you to join lawsuits all around the country because of this interpretation that they're going to restrict these kind of decisions only in the circuit where they're made. That's bad. Talk about new science. This was the science that the Science Advisory Board said was junk science. As you can all obviously see, this is the way the line snakes through the data and gives you the correct answer. Really? That's a shotgun blast of data. That's what the Science Advisory Board said. It does not predict anything. And EPA and the state of Minnesota just adopted its nutrient criteria using that same method that the Science Advisory Board said stop using. If you think they're actually looking at the facts, think again. This was a TMDL, nutrient TMDL, I was involved in Pennsylvania, where they said this is a concrete line ditch going through Harrisburg, Pennsylvania. This is on the Paxton Creek. And it had a low amount of insects in it. What a shock. There weren't too many insects living in the concrete line ditch. The nutrient levels were also a little bit high in that ditch. EPA said, well, of course, the nutrients are the cause of the fact that the invertebrates aren't there. Oh my, think about that one. What is it the US is now going to start classifying all kinds of ditches, and you all have ditches. I mean, there's one thing about Minnesota. There are some high-lying areas, but you got a lot of low-lying areas. You got a lot of roadside ditches where the water accumulates because that's the way you make things so it can run off. And they're now going to say, suppose there's low invertebrates in a roadside ditch. What a shock. But the nutrient levels are a little high. Oh my, these two things are connected. You need to be regulated. So they're not looking at facts. Speaking of also not looking at facts and going back to your Minnesota decision to say nutrients, nitrogen must be regulated, why were they saying it? Because they were using a relationship or a decision done for Chesapeake Bay. Here's Chesapeake Bay down here. Now, here's nitrogen. This is the amount of nitrogen caused by urban centers and the wastewater plants. Roughly 35 or 40%, say. Well, that's a fair amount of the total pie. There's the whole pie. That's the municipal piece. Now let's go to the Gulf of Mexico. See that little slice right there? That's the entire urban and wastewater contribution to the Gulf of Mexico, less than 9%. You want to figure out how much Minnesota's percentage is of that, given how far you are away from the Gulf of Mexico? You know, you're like 0.2%. So, in this situation, let me back up for a second. In this situation, you could make that go to 0. and you're not going to meaningfully reduce the entire pie. So you're going to spend billions of dollars in this state on nitrogen reduction, and you're not going to be able to measure the change in the Gulf of Mexico. What a good way to spend your resources. And oh, by the way, it doesn't stop at wastewater. Remember I said Chesapeake Bay, a bunch of folks got sued for stormwater communities. Well, here's the difference in cost on removing nutrients in stormwater versus removing nutrients from agriculture or from wastewater plants. That's over $200, $100 to over $200 a pound of nitrogen removed, where it's $15 a pound at wastewater or $2 to $3 a pound from agriculture. So the cost associated with doing things on stormwater dwarfs the cost at wastewater. So anybody that's going to be regulated that way, you're going to spend way more money. Okay, so one of the obvious conclusions in the Gulf of Mexico slides are your municipal sources are minor. No amount of control is going to materially change the hypoxic zone in the Gulf. Mississippi River and agricultural runoff actually controls what happens down there. Everybody already knows that. They know that, but they're regulating you instead. But why? Because you're the only source they're allowed to regulate under the Clean Water Act. Oh my. Because I'm the only one they can regulate and it doesn't make a difference, they regulate me anyway? The answer is yes. This is a train wreck in the making. It's coming because it's already happening in Chesapeake Bay. We already see it there. You're just next online. Now let's just do a couple quick slides on outdated science. This one's affecting a bunch of you here already. Chloride. Show of hands, does anybody have used water softeners, or their local communities have water softeners? Yeah, a few of you, right? Yeah. Water softeners use salt base. Salt base makes the chloride level go up. Chloride's chloride. It just goes right through a wastewater plant. It's not removed. And communities throughout the state are now starting to receive chloride limits. You know, the only thing that you can do at a wastewater plant for chloride is put in reverse osmosis. Oh my God. If you have reverse osmosis, uses enormous amount of electricity, think greenhouse gases. And oh, by the way, the byproduct of it is you don't destroy chloride, you just concentrate it in what would now be a toxic waste stream, and then you've got to figure out where you're going to transport it to. Best I can figure, you've got to send it to somewhere out in the Atlantic or Pacific Ocean. Which is closer to you? Show of hands? Atlantic or Pacific? Maybe you could give it to the guys that are fracking and have them inject it down somewhere. But you're not discharging it anywhere. Red River of the North. I gotta love this one. City of Moorhead, step right up. Did you know that you were violating the 1909 Border Water Treaties Act? No, I didn't know it either, until we got this letter a few months ago from the PCA saying the reason the Red River of the North now needed to be regulated for phosphorus is because it's violating a treaty. When was the last time the state of Minnesota was authorized to implement international treaties? I didn't see that one yet either. Turbidity standards for Minnesota River, we talked about that one a little bit, and this one is happening routinely. This has just got to stop. They're putting out draft TMDLs. You're sending in comments on things that need to be changed. They're sitting on the comments and then just starting issuing permits as if they finalized the TMDLs. What does that do? It takes away your right to challenge their decision as arbitrary, because they're ducking the process that's supposed to apply to making a decision. Violating your due process rights. All right, so what's the unvarnished truth? It's sad to say, more for EPA, maybe a little bit less for PCA, but they will squander your resources, and you will prevent you from doing higher priority public work projects. I mean, it's not like water and wastewater are the only things you have to spend money on. I mean, there's water, there's sewer, there's other utilities, there's hospitals, there's roads. These are all things that make your society livable. They're not really looking at any other priorities. They're not responding to reasonable scientific issues. I can absolutely tell you they don't care how much it costs. Matter of fact, they proudly will announce the Clean Water Act does not allow consideration of costs. It just doesn't allow it. You just need to step up and spend whatever we tell you. and your municipal and fiscal priorities are therefore not relevant to regulatory authorities. And you really need to get some control on this, and you have to start doing something to limit these arbitrary mandates. So what to do, and the panel will talk a little bit more about this. You need to protect your due process rights. Well, let me back up for a second. I'll give you an example. In New Hampshire, EPA was just running roughshod over a stack of communities and just giving stringent nutrient limits. Why? The environmental groups were just saying, we want them lower. Set the limits of technology. What did we do at that point? Because they wouldn't listen to anything, we sued them in every single court we possibly could. Until finally, they said, uncle. By the way, that's not a preferred way to run an airline, just so you know. I'm not recommending that we just all sue people all the time. But when they're absolutely not listening and violating due process rights, and so I got a compliment at the end of the process. One of the local attorneys said, you know, John, you managed to make yourself a bigger pain in the butt than the Conservation Law Foundation. Well done. Oh, that was it. You know, you need to protect those due process rights. You have to make yourself heard. That you're going to refuse to let somebody squander your resources, state. Have to. If they're not going to respond to your science, you need an independent panel that'll look at it. And you need to get your legislature to say it's required. EPA has required science advisory board reviews. Why doesn't the state of Minnesota? Variances. We did this in Iowa. We got the legislature to adopt a rule that said, when you can show there's no reasonable relationship between costs and benefits, you ought to be able to defer the requirements. Or in other words, why would you make me spend money on something that you know isn't going to produce a benefit? Let me defer it. High cost cutoff. If we can't stop them from just issuing rule after rule after rule, there has to be a pain threshold above which they can't just keep adding on. And at that point, you just get longer and longer time to get the work done, but they don't just keep piling it in. High cost cutoff. Last but not least, prioritization. You have to be able to put some of your other public works projects in the mix. And that's part of what's called integrated planning. Integrated planning, if you do it properly, you can show where all your money is being spent and why you need to do it in a certain order. But, and you would need to probably get your legislature to order the state to allow integrated planning. EPA is saying it should be allowed. Everybody's talking a good game, but nobody's doing it. And unfortunately, I think you're going to have to file some suits, and I think Steve is going to talk about one of them. But that's my recommendations, and I will turn things over to Bruce to give us a bit of what's happening on the ground. Thank you.
This is a big day for Moorhead, apparently. I just want the mayor to know that my son works for your city, and my wife would appreciate it if you'd be nice to him. She's still looking out for her little boy. I want to start out with just a little bit of background so you know who's talking to you right now. As you know, my name is Bruce Nelson. I'm the Executive Director of the Alexandria Lake Area Sanitary District. I've held the position since May of 1978. A period of 36 years old. I was a slender 29-year-old at the time. I have a BA in economics from the U, also a BS in business. I served in the United States Air Force as an intercontinental ballistic missile launch crew member from 1971 to 1975. I then worked for the city of Fridley for 2 years, for 1 year, and the city of Faribault for 2 years. The sanitary district provides sewer service and treatment within a 100 square mile area, serving a population of approximately 23,000 people with 9,900 sewer accounts. As a regional sanitary district, we provide contract service to the cities of Alexandria, Nelson, and Ferrata, and the townships of Alexandria, Carlos, LaGrande, Hudson, and Lake Mary. The district has 21 full-time employees and 7 seasonal employees. Digress for a second, a fellow on the radio talk show asked me one day how many employees we had working for us, and instead of saying 21, I said about half. I quickly recovered, and the guys out in the trucks, most of them did hear it. So our collection system has 222 miles of gravity sanitary sewer. Yesterday, driving down from Alexandria to Rochester was, I think, 221 miles. So that gives you an idea. We've got 52 miles of force main pressure line, 119 lift stations, 48 common grinder stations, and 124 residential grinder stations. If we had time, I could explain to you why we have so many. The district operates an advanced wastewater treatment facility with tertiary treatment. Daily flows approximately 2.8 million gallons a day. An average discharge concentration of BOD and suspended solids is about 2 parts per million, 2 milligrams per liter. And our phosphorus discharge is 0.020 milligrams per liter, or about 20 parts per million. The treatment facility has not exceeded a discharge limit in 37 years of operation. Our user charge fee for single-family dwelling is $23 a month, or $276 a year. Although, in full disclosure here, the capital debt that we have for improvements is paid solely from connection charges, user fees, and property tax. So that brings the user charge amount down a little more than it might be. And otherwise, it'd be about 30 bucks a month. In the early 1990s, we began to experience NPDES permit changes that we did not fully understand. In response, we began to educate ourselves on these changes. As part of the effort to educate ourselves and respond to these issues, we eventually hired legal and environmental consultants. The advent of Minnesota Environmental Science and Economic Review Board, MESRB, provided the opportunity for wastewater operators to share the cost of obtaining a scientific, technical, and legal counsel on these common regulatory issues. It also provided us with the opportunity for the first time to speak with one voice. MESRB has been highly successful in educating our members on the activities of the MPCA and the EPA. In its early years, MESRB experienced a fair amount of success in moderating what we considered unwanted, unneeded, and excessively costly regulatory action. If you were to view the MESRB website, and that's mesrb.org/, that's something you should really do. It would provide you an opportunity to learn of what MESRB has accomplished, and it's a long list. And the quality of our studies and our written communications and documents far exceeds the letters and documents that we get back from other sources in the regulatory agencies. And that's my opinion anyway. In recent years, the number and type of issues has increased. Why is this? John basically went over it. Increased EPA mandates, third-party litigation and threats of litigation, increased use of divide and conquer strategy by the MPCA. Well, Wisconsin's doing it. Well, Rochester agreed to this. Decision to reverse past policy and practice by using costly permit limits based on only the available and insufficient data prior to listing water bodies as impaired. A reluctance of the regulated community to litigate, partly due to cost and financial risk of losing and public perception. Those are huge things. And the attorneys in this country have done a great job of scaring us out of going into litigation. I'm talking about everybody, and probably for good reason. You will also note that the state and federal governments make a very limited dollar contribution to the type of environmental projects that we're involved in. That didn't used to be the case. If you were to judge how a state or a government valued its natural resources, you might look at how much money they spend on it themselves. And of course, we have an unwillingness in the federal government, I'm talking about Congress, to regulate all pollutant sources, not just one. I want to give just a quick summary of the district's experience in one area. The district treatment facility was constructed in 1977 and discharges treated wastewater to a shallow lake with an average depth of 4.5 feet and a maximum depth of 8.9 feet. During the Depression, it was dry. It's always had a reputation of being a poor quality lake. The lake is known as Lake Winona, and it is impaired by excessive nutrients. No argument there. The shallowness of the lake exacerbates this condition and makes it very difficult to reach what one would call a clear lake condition or clear water condition. And that's what the MPCA wants for every lake and river, but in particular lakes, regardless of how the lake is made. I mentioned my son earlier. You know, when he was born, I thought, boy, you know, maybe this guy could be an Irishman. No.
I'll just mention, we've learned that there actually is a memorial service going on next door. I don't know how they scheduled that during the middle of our conference, but unfortunately, we're going to be suffering from bagpipes and trumpets for the next couple hours. And I say suffering as someone who went to McAllister College and likes bagpipes.
The lake, for the most part, the property owners around the lake accept the condition of the lake, and the lake's waters has improved since our plant has been there. The lake was placed on the MPCA 303D listing of impaired waters in 2002. We were told by the MPCA that this listing would have no impact on any regulatory action. It was only a planning process known as a TMDL study. In 2006, an environmental group insisted that MPCA impose a strict phosphorus limit because of nutrient impairment in Lake Winona. The environmental group challenged the district's permit, and we were forced to litigate this challenge before the Minnesota Court of Appeals and the Supreme Court. We won at both levels, and the reason we fought it was not because of the limit that they wanted, but because without our permit being issued, we could not expand our wastewater facility, which was basically at or operating above the actual capacity. So the state started in 2007 a TMDL project study of Lake Winona. Yet today, in 2014, or 7 years after it was initiated, we have no idea when the TMDL study and TMDL implementation plan will be completed. Nevertheless, in July of 2013, the MPCA issued a new NPDES permit, lowering our phosphorus limit by more than half, from 300 parts per million to about 157 parts per million. These are very low numbers, and so they're looking for a removal efficiency of roughly 98%. To meet this new limit, our engineering firm estimates it would cost us $20 million in capital cost and $300,000 additional per year in operating cost. Our environmental consultant and documented experience predicts that when and if the shallow lake attains a clear lake condition, sunlight will reach the bottom of the lake and the lake will then become choked with weeds. All of this time, all of the money and effort, and what will it have gained for these property owners? A lake that is effectively unusable. And we've seen that with urban lakes, small urban lakes that have been drained and cleaned up, and everybody's happy because in the spring the water's clear, and by July or August it's weed choked. So the DNR is not really thrilled about emptying out urban lakes. They're great to do it on.
These issues are not going to go away, and we will continue to push back and try to require the best science ever. But the fact is that this is going to get more expensive, and the current grant programs are not adequate. I think for those of you who've tried to get some of the grants and stuff, even though our cities aren't rich, a lot of them still don't qualify for a lot of these programs. And we think that, you know, if the state is going to be requiring us to do this, they got to help pay for it. And so we think that we either need to be creating some new funding programs or increasing funding to existing programs, but changing the criteria so that more of our cities are eligible to get financial assistance with these programs. And again, our next steps on this is doing some research and watching the election results. This is an area perhaps where if the DFL stays in control, we might have better luck trying to get some more money on this area. Really focusing on that need to help cities pay for it. So those are three of the ideas. There's some other ideas John has had that we'll also be looking at, but hopefully you know, we can try and make it, you know, an impact on some specific ways through the legislative process.
Good morning, everyone. Steve Nias, bottle washer, I guess you could say, for MESRB. And I just want to very quickly touch on the nature of the lawsuit that MESRB is looking to pursue. And along with that, I'm going to try and give you a little bit of political cover and maybe a little bit of homework to do once you get back to your home communities. In terms of what this lawsuit is going to be, it's what's going to be called a declaratory judgment action, which means that MESRB is going to go to the Minnesota Court of Appeals, ask them. Now, you remember all the issues that John talked about, all the issues in the regulatory tsunami. We're dealing with one piece of that, those river nutrient standards. We're going to be asking the Court of Appeals to declare that the rules as adopted were invalid because there's three different criteria. The provisions were unconstitutional, that they exceeded the PCA's statutory rulemaking authority, and that they were adopted through violations of proper rulemaking procedures, and it's really going to be that third one. So the general issues are going to be, MESRB raised a number of technical issues during the rulemaking process. The rules as set up will be looking at your community's, your receiving water's levels of phosphorus, and three what we call response variables: chlorophyll, biochemical oxygen demand, and dissolved oxygen flux. If those terms don't make any sense to you, it's okay, just forget about it. The chlorophyll A part of it, we're like, yep, that's fine. If you're discharging to a river and there's too much chlorophyll and you have algae, yeah, we should get a limit for that stuff. The other two are brand new. And MESRB pointed out again and again to the agency, this stuff has not been peer reviewed, it hasn't been examined, it's not being used anywhere else for nutrient standards, you gotta stop it. And PCA said, we've done enough peer review, we've looked at everything, we've gotten endorsements from all these different groups. When we actually went through and looked at the peer review, PCA was peer reviewing its own stuff. Literally, the same guy who was proposing the river nutrient standards, the same scientist, did his own peer review of his own stuff. How is that independent peer review? So that's going to be the biggest point that we're going to be focusing on.
If you're schizophrenic, it might be.
Along with that, and this is one of the things that'll bring in the issues John talked about, you'll hear the same song and dance from the agency. Well, it's a weight of evidence approach. We're going to look at the situation in your individual community. EPA doesn't care. PCA can claim all of the flexibility at once. EPA, in fact, filed a letter during the rulemaking process saying, if you have a number, PCA, we expect you to enforce it on the point sources that you regulate. So no matter how much assurance you get from the state level, feds don't care, and they don't want to pay attention to this discussion about cost. And finally, errors in the rulemaking record. We asked them to look at, BOD and DO flux. Again, forget what those mean. And how do we know that these are actually caused by excess nutrients versus something else? Oh, we examined that, it's all fine. Go back to point number 1. So that's what the lawsuit is going to look like. Now, the political cover of this piece, and I touched on it a little bit earlier because I imagine, your policymakers, you're going to go back to your city councils, talk about, CGMC is looking at participating in this lawsuit, and somebody's going to say, wait a minute, why do you oppose clean water? Why don't you want to clean up our rivers? Let me make very clear, this is not a war against clean water, and it never has been. MESRB has never been about that. This is a war against stupid science and bad policy making. As I said before, if you have algae in your receiving water, if you have too much phosphorus and it's causing problems with eutrophication, yeah, you should get a limit. And I don't think anybody in your communities is going to disagree with that. It's these other factors that PCA has decided out of the blue to include in the process to determine whether there's a downstream impairment. That's the stuff that we're attacking. So if anybody tries to claim that this is a lawsuit against clean water, please put them on the spot about it right away. And finally, the last point, as far as your homework, a couple of websites I want you to check out. Bruce mentioned the one earlier, meserb.org, M-E-S-E-R-B. There's a lot of folks in this room who are members. In fact, the presidency is held right here in Rochester. A lot of you have not joined or were previously members and are not anymore. I won't mention any names, but Fairmont, Worthington, Owatonna, Austin, Bemidji, Hawley, Princeton, and St. Peter. But if you're not in, we would love to have you. You are more than welcome. And I do want to stress, this is a big, big issue. MESRB is going to be looking to fund this lawsuut through a voluntary assessment on its members. So the members have just paid in their assessment for dealing with all the other stuff John talked about for this next fiscal year, and now we're going to be going back to them saying, can you give us a little bit more for funding this lawsuit? And obviously, we're going to be appreciating any help that we can get. We've sent letters to other groups, the League, the Coalition here, the Chamber of Commerce, all sorts of different groups, asking them for help. Check out our website. Also, if you are a member of MESRB, please go talk to your public works staff and tell them in the next few days you're going to be getting a letter from your president asking for a voluntary contribution. If you support this effort, please respond so that we can get this lawsuit going because time is not on our side. I'll stop there and thank you for your time.
I particularly want to thank John for coming out on his own dime from Washington. Actually, he was in Iowa, so he just came from Iowa. But still, it's a lot of time and effort on his part. So I want to particularly thank him. We will be voting on this later today on whether you want to authorize CGMC to participate in the lawsuit. So we will have a little more discussion. Actually, we're going to have partly a political discussion later too, so this isn't the end of it. I think because we're on a tight time frame, we are going to have to not take questions now. We're going to have to move on to the next thing, unless there's really some pressing question that somebody wants to ask. Okay, John will be around. Oh, is there? Someone? Okay.
I guess, aren't we really talking about the disconnect of the electorate from the facts that we're talking about of these issues versus the political rhetoric? And what, as elected officials, we hear the regulations and that, what basis would they have to really comply with some of this and basically force litigation against some of these expenses?
Anybody want to take that? I think here's the way I look at it from in terms of the elected officials and all this. And I think the beauty of this, now I'm not sure on this, but when we sued the last time, we're not a big suing organization here, but it was like 2008, wasn't it? And doesn't the organization have standing? We don't have to have individual cities sued, do we?
That's correct. The organization does have standing. CGMC had sued on the PCA's phosphorus effluent rule back in 2008. PCA actually tried to knock CGMC's lawsuit out on that specific basis, saying, well, you're a membership organization, you don't have standing. Although the rest of the lawsuit didn't go as well, the Court of Appeals ruled firmly in CGM's favor that yes, an organization like this does have standing to sue.
Yeah, and I think that's only part of the answer, that really the coalition has not been active in the environmental area for several years because of budgetary problems, budgetary issues, other things were a higher priority. We'll talk about that later today, but I think the elected officials who have not been involved for 8 years maybe are going to have to get involved if we're going to stop this. We've tried the regulatory policy scientific approach. People are ignoring us. So now it has to be lawsuits and legislative and media. And so if you give me the authority and the resources to go forward, we will do that, and we will make a huge difference in this area. So the elected officials have to stand behind the organization. You're going to have to contribute. Somebody's going to have to contribute to fund this effort, but we can be successful. So was that answering your question or not? No? Why don't?
I just want to say one thing. Until Congress decides to regulate, the areas are not regulating now, the agricultural industry, these battles are going to continue. The environmental groups, they're like any association, any of these associations out there, whether the ACLU, the NRA, the church, they're living organisms, they want to continue to live, they need to have something to fight against. All they have right now is us and industry. That's why they put forth these efforts, in my opinion. So the legislation in Congress has to change, and we can't control that very well.
Yeah, we can do a lot here at the state level because the PCA is really not acting appropriately. So I'm going to ask now, Craig, you could talk to John. John and our panelists will be right outside the back door here. If anybody wants to talk to them individually, please do that. But we promised people 11:30 today, and we want to stick to that. The next issue, so if the panelists could vacate. And now I'm going to, let's give them a round of applause.